Welcome to FE1 Made Simple, where we break down complex legal topics into what you need to know for the exam, clearly, confidently, and case-based. I'm Jessica, and today we're diving into sources of EU law, a foundational topic that underpins nearly every other area of European Union law. This topic is essential. You cannot begin to understand direct effect, supremacy, or enforcement mechanisms like member state liability unless you first understand where EU law comes from, what types of law exist, and how they interact. And the FE1 examiners know it. In fact, this topic has appeared on countless exams. March 2023, Question 3 asked about the nature and legal impact of legislative instruments under Article 288, TFEU. October 2022, Question 2 compared regulations and directives, emphasizing their different modes of application. March 2021, Question 1 focused on the legal basis for legislation and the limits of EU competence, an issue that sits at the heart of the sources of EU law. So, what will we cover today? This episode is structured around the three core sources of EU law: primary law, the treaties, and constitutional norms. General principles, unwritten but binding principles, developed by the CJEU. Secondary law, legislative acts like regulations, directives, and decisions, plus soft law, and newer forms like delegated and implementing acts. Together, we'll walk through the hierarchy, explain the constitutional function of each source, and, crucially, we'll integrate the leading CJEU decisions that define their application. This episode won't just prepare you to explain the law. It will help you argue and apply it, exactly what's needed in the FE1. Let's start with the treaty framework, the source from which everything else flows. Let's start at the top of the hierarchy, primary law. This is the constitutional core of the EU legal system. Every act of an EU institution must be grounded in the treaties. It's the legal bedrock of the Union. So what exactly does primary law include? First and foremost, it's the founding treaties. The Treaty on European Union, TEU. The Treaty on the Functioning of the European Union, TFEU. The Treaty establishing the European Atomic Energy Community, Euratom. These treaties do three things. They define the competences of the EU, the fields in which it can legislate. They establish the institutions, the Commission, the Parliament, the Council, and lay out how they interact. They impose obligations on member states to comply with and implement EU law. It's worth remembering that Article 5 TEU limits the EU to acting within the competences conferred upon it by the member states. This is the principle of conferral. And this limitation is more than academic, it's examinable. For example, March 2021 Q1 asked about the legal basis for legislation and required students to explain how the limits of EU powers arise from the treaties themselves. But there's more to primary law than just the TEU and TFEU. It also includes amending treaties, like the Treaty of Lisbon, accession treaties, which govern how new member states join, protocols annexed to the treaties, and crucially, the Charter of Fundamental Rights of the European Union, which was given binding legal status under Article 6.1 TEU by the Lisbon Treaty. Then there's a more subtle category, the general principles of EU law. These are not written down in the treaties per se, but the Court of Justice has consistently held that they form part of primary law. These include legal certainty, proportionality, fundamental rights derived from the European Convention on Human Rights, ECUNTR, and from the constitutional traditions common to the member states. The key case here is International Handelsgesellschaft, Case 11/70. The German government argued that an EU regulation violated fundamental rights, guaranteed under the German constitution. The CJEU firmly held that EU law has supremacy, even over national constitutional norms, but it also ruled that fundamental rights are general principles of EU law. This was groundbreaking. It meant that even in the absence of written treaty provisions, the court could annul EU acts that violated fundamental rights. This doctrine was developed further in Nold-Verve Commission, Case 473, where the court again confirmed that unwritten general principles, including the protection of property and respect for family life, form part of EU law. Today, with the Charter of Fundamental Rights now binding under Article 6 TEU, these principles have found written expression. But remember this for exams. The court recognized and enforced fundamental rights even before the Charter was legally binding, based on general principles. So, in summary, primary law is not just treaty text. It includes unwritten principles and binding charters. It's the legal ceiling. No act of the EU can exceed it. It's central to institutional balance, legislative competence, and rights enforcement. And for your exam, you must be able to define what falls under primary law, apply it in the context of legislative competence or fundamental rights, and link it to supremacy and direct effect, which we'll return to in other episodes. Now that we've covered primary law, let's move to secondary law, the legal instruments through which the EU puts its powers into action. Secondary law is derived from the treaties. It includes binding and non-binding legal acts, primarily governed by Article 288 TFEU. Under this provision, the EU may adopt regulations, directives, decisions, and may also issue recommendations and opinions. Let's unpack each one, beginning with regulations. Regulations, the strongest tool in the EU's legislative arsenal. A regulation is binding in its entirety, directly applicable in all member states, and does not require national transposition. In other words, it has immediate legal effect across the EU once it enters into force, usually 20 days after publication in the official journal. In Case 34/73, Fratelli Variola SpA v. Amministrazione Italiana delle Finanze, the court held that regulations are directly applicable and must not be reproduced or altered by national law. The principle? EU law must be uniform and simultaneous in application. In Polite v. Italian Ministry for Finance, Case 43/71, the court confirmed that regulations produce direct effect, not just in theory but in practice. They create rights and obligations enforceable in national courts. Similarly, in Rocca v. Hauptzollamt Mainz, Case 98/78, the court stressed that the unity and uniformity of EU law required that individuals must be able to rely directly on regulations, reinforcing their constitutional role. For your exam, expect a question on the differences between regulations and directives, or a problem question involving whether a measure needs transposition. Always remember to cite Article 288 TFEU and these key cases. Directives. A directive binds member states as to the result to be achieved, but leaves discretion as to the form and methods of implementation, and must be transposed into national law within the time limit set. So, while a regulation is like a uniform rulebook, a directive is more like a policy target. It tells the member state what to achieve, but not how to do it. Take, for example, the Single-Use Plastics Directive, EU 2019/904. It aims to reduce plastic pollution, but Ireland could implement it via plastic bans, levies, or public campaigns, as long as the goal is met. But what happens if a directive is not implemented in time? This opens the door to direct effect, a key doctrine explored in cases like Van Duyn v. Home Office, Case 41/74, where the court held that directives could have vertical direct effect if the implementation deadline has passed and the provision is clear, precise, and unconditional. And Ratti, Case 148/78, which reinforced this by stating a member state cannot rely on its own failure to implement a directive as a defense. So even though directives don't apply automatically, they can still create enforceable rights, especially when the state has failed to act. For the exam, be ready to discuss the conditions for direct effect of directives and contrast them with regulations. Use Ratti and Van Duyn to illustrate. Decisions. Decisions are binding in their entirety, but only on those to whom they are addressed. Most commonly, they're used to target specific member states or companies. Example, Commission v. Ireland, Case 2-32/78, where the Commission issued a decision requiring Ireland to stop giving illegal state aid to Irish airlines. In this sense, decisions are tailored enforcement tools, not general laws, but specific commands, recommendations and opinions, the soft law tools. These are non-binding. They allow EU institutions to guide, interpret, or nudge without imposing obligations. They cannot be challenged in court and do not produce legal effects, but they may influence interpretation or inform future legislation. That brings us to an important clarification: implementing versus delegated acts. This comes from Articles 290 and 291, TFEU, Lisbon's response to the growing complexity of EU governance. Delegated acts allow the Commission to amend or supplement non-essential elements of legislation. They're quasi-legislative and must be authorized by the European Parliament and Council. Implementing acts are purely executive, used where uniform implementation across the EU is necessary. These are often adopted via the comitology system. This can get procedurally dense, but in exams, focus on the distinction. Delegated equals amending powers. Implementing equals execution powers. Fixing example. A directive on environmental standards might empower the Commission to adopt delegated acts updating pollution thresholds and implementing acts setting harmonized monitoring methods. In the exam, you might be asked about the legal basis for a measure or to critique the use of delegated powers. Remember the relevant articles, 290 and 291 TFEU, and use clear examples. Welcome back. In this segment, we're tackling two closely related themes that frequently show up in FE1 EU law exams: the legal basis for EU legislation and the hierarchy of norms within the EU legal order. Let's start with the idea of legal basis. Every EU legal act must be based on a specific treaty article that gives the institution the power to act. This is essential, not just for legality, but also to determine which procedure will be used, which institutions are involved, and what kind of act can be adopted, regulation, directive, etc. So if you're asked, how does the EU choose which article to legislate under? The answer is, The legal basis must reflect the primary objective of the Act. In Commission v. Council, titanium dioxide case, the issue was whether an environmental measure should be adopted under Article 100, Internal Market, or under Article 130, S, Environment. The court ruled that the choice of legal basis depends on the aim and content of the measure. Since the main goal was environmental protection, Article 130S was the correct basis, even though it had procedural consequences. For your exam, if a measure has more than one possible legal basis, you must assess which is dominant and use that one, unless the purposes are truly inseparable, in which case a dual basis may be used, but only if the procedures are compatible. In Recovery of Indirect Taxes case, the court reaffirmed that where one aim is incidental and another predominant, the predominant aim determines the legal basis. However, if both are equally important and procedurally compatible, a dual legal basis may be acceptable. But there's a catch. If the treaty expressly excludes multiple legal bases, or the procedures conflict, then only one legal basis can be used, and this has serious implications, as legislating under the wrong article can invalidate the entire Act. Back to the titanium dioxide case. The choice of an incorrect legal basis was not a technical error. It struck down the Act. That's why identifying the right legal basis isn't just procedural, it's constitutional. Now let's connect this to hierarchy of norms. At the top of the pyramid is primary law, the treaties, TEU, TFEU, Charter of Fundamental Rights, Protocols, and General Principles of EU law. Beneath this, secondary law, like regulations, directives, and decisions based on the treaties. Then we have delegated acts, Article 290 TFEU, which modify or supplement non-essential parts of legislation. Implementing acts, Article 291 TFEU, which ensure uniform implementation. Finally, soft law, recommendations and opinions which are non-binding. In Qadi and Al-Barakat, Shinta vom Council and Commission, joined cases C402/05P and C415/05P, which are essential when discussing hierarchy. The EU had implemented UN Security Council sanctions through an EU regulation. Qadi challenged it, arguing it breached his fundamental rights. The court held that fundamental rights form part of the general principles of EU law, which are higher in the hierarchy than international agreements, even binding ones. So the regulation, although adopted to comply with international obligations, was annulled for violating superior EU norms. In an exam essay, used Qadi to argue that the Charter and General Principles act as a constitutional standard, that even binding regulations can be struck down if they violate higher principles. Remember, every EU act must comply not just with its legal basis, but with the entire hierarchy, including the Charter, General Principles, and the treaties themselves. A classic question might ask you to assess whether a piece of EU legislation had a valid legal basis, or what happens if it doesn't. Use titanium dioxide and Qadi to build your argument, and always assess the procedural consequences, like needing the Council or Parliament's involvement. Welcome back to FE1 Made Simple. In this segment, we're diving into one of the more technical, yet crucial, parts of EU legislative structure, delegated and implementing acts, and the comitology system that supports them. If you've ever wondered, what happens after a regulation or directive is adopted? This is the answer. This is how the EU updates and implements laws without reopening the entire legislative process. First, what are delegated and implementing acts? Let's start with their treaty bases. Article 290, T. FEU governs delegated acts, while Article 291, TFEU governs implementing acts. Both provisions give the European Commission power to adopt further measures, but the nature and scope of that power differ significantly. Let's begin with delegated acts governed by Article 290, TFEU. A delegated act allows the Commission to supplement or amend non-essential elements of EU legislation. Think of these as technical updates or refinements, not changes to the core principles. These are non-legislative acts, but they're critical because they adjust the substance of an existing law. For instance, adding new scientific standards, updating annexes to a regulation, modifying procedural details. For example, if a regulation on food additives needs to be updated to reflect a new health study, a delegated act might add or remove substances from its annex. Some of the key features of delegated acts include that the legal basis for delegation must be clearly stated in the original legislative act. The Commission is also required to consult expert groups before adopting the act. Additionally, both the European Parliament and the Council have the power to revoke the delegation or object to the act, usually within a 2 to 4 month time frame. Unlike implementing acts, delegated acts do not go through the comitology procedure, but the Parliament and Council still retain control after the act is adopted. Important exam point: delegated acts play a vital role in maintaining the technical accuracy of EU law without reopening the entire legislative process. In exams, you might be asked whether a power should be delegated or not. In such cases, check whether the proposed change involves a non-essential element. That's the key test. Now let's turn to implementing acts, governed by Article 291 TFEU. Unlike delegated acts, implementing acts deal with how legislation is put into practice. The focus here is on execution, not modification. Although implementation is generally carried out by member states, there are instances where a uniform approach across the EU is essential. That's when the Commission, or in rare cases the Council, steps in to adopt implementing acts. Common examples include defining how customs procedures should operate, setting out technical criteria for product labeling, or coordinating EU-wide databases. Some of the key features of implementing acts are: they are always based on existing legislation. They are purely executive in nature, meaning they cannot amend the law. They are often adopted through a system known as comitology. So what is comitology? Comitology refers to the committee system through which member states oversee the Commission's use of its implementing powers. It ensures a balance of power between the Commission and the member states. There are 2 main procedures used in comitology. First, the examination procedure. This applies to important policy areas like taxation, the environment, and health and safety. Here, a qualified majority of member state representatives must approve the proposed measure. If the committee doesn't reach a majority, the Commission must either amend the measure or refrain from adopting it. Second, the advisory procedure. This is used for less significant measures, such as awarding certain types of funding. Member states provide a non-binding opinion, and the Commission ultimately retains discretion over the final decision. Let's take an example. Suppose the Commission wants to adopt technical standards for agricultural inspections. Under the examination procedure, a committee made up of experts from each member state votes. If they reject the proposal, it stalls. If they approve it, or even if no opinion is given, the Commission may proceed. However, this system is not without its challenges. There are a few legal and procedural issues to watch out for. Sometimes the distinction between delegated and implementing acts becomes blurry. It's not always clear whether a measure is amending legislation or simply implementing it. This ambiguity can create disputes and institutional tension. Comitology itself can be complex. While it provides democratic oversight, it can also slow down decision-making and reduce the Commission's flexibility. Finally, judicial review plays a key role. If a measure is adopted under the wrong legal basis, say using Article 291, when Article 290 should have been used, the Court of Justice of the EU, CJEU, can annul it. So, how do you approach this in an exam? Be ready for a problem question that asks whether an act is delegated or implementing. You'll need to ask, does the act amend or supplement existing law? If so, it's likely a delegated act. Does it set out details for how existing law should be applied uniformly? That points to an implementing act. What level of discretion does the Commission have? Is the act checked by the Parliament and Council, as with delegated acts, or by a committee of member states, as in comitology? And importantly, be familiar with comitology's structure and its role in maintaining oversight, legal uniformity, and democratic legitimacy within the EU legislative system. Coming up next, we'll explore the differences between regulations, directives, and decisions, linking each to landmark case law and practical application. Welcome back to FE1 Made Simple. In this segment, we're taking a deep dive into the three most important forms of EU secondary legislation: regulations, directives, and decisions, as laid out in Article 288, TFEU. This is absolutely essential for the FE1 exam. You must understand their legal effects, binding nature, and the case law that underpins their use and enforceability. So let's take them one by one. We'll begin with regulations. According to Article 288 TFEU, regulations are defined as having general application and being binding in its entirety and directly applicable in all member states. In simpler terms, a regulation is immediately binding and doesn't need to be implemented through national law. It overrides any conflicting national law and can be enforced in domestic courts, provided its wording is clear, precise, and unconditional. Let's look at some key case law. In Variola Varther of Amministrazione delle Finanze, Case 34/73, the CJEU ruled that national governments must not reenact or restate the provisions of a regulation, as that would undermine its uniform application. In Politi 5 Italian Ministry for Finance, Case 43/71, the court confirmed that regulations create rights and obligations not just for states, but also for individuals. They have direct effect. In Rocca 5 Hauptzollamt Mainz, Case 98/78, the court reinforced that for EU law to be uniform across all member states, individuals must be able to rely on regulations directly. So for your exam, remember, regulations are binding in full, apply automatically, and take precedence over national laws. Now let's turn to directives. Directives, also governed by Article 288, TFEU, are binding only in terms of the result to be achieved. The choice of form and methods is left to the member states. This gives flexibility. For instance, Ireland might implement a directive through ministerial regulations, while France might use legislation. However, there's a key difference. Directives are not directly applicable. They must be transposed into national law within the time frame set by the directive. That said, directives can have direct effect, but only if certain conditions are met. We cover this in more detail in our episode on direct effect, but here's a summary. Case law includes Marshall v. Southampton, number 2, case 271/91. This case confirmed that a directive can be enforced vertically by individuals against the state or state bodies, but not horizontally against private parties. Van Duyn v. Home Office, case 41/74. The court held that where a directive is clear, precise, and unconditional, and the deadline has passed, individuals can invoke it before national courts. Fratelli Costanzo vom Comune di Milano, case 103/88. This case made it clear that national authorities must apply directly effective directives even if they conflict with national law. Exam tip: always make a distinction between direct applicability, which applies to regulations, and direct effect, which directives can sometimes have. You should also be able to explain when a directive can be enforced. Now let's look at decisions. Decisions are also mentioned under Article 288, TFEU. They are binding in their entirety, but only on those to whom they are addressed. They're typically used when the EU wants to address a specific member state, a company, or even an individual. Examples might include a decision to stop state aid going to a national airline, a competition law ruling addressed to a company, or a funding approval directed to a particular applicant. Relevant case law includes Grad v. Finanzamt Traunstein, case 9/70. This case showed that decisions can also have direct effect if they are clear and unconditional. Albaco, Margarinefabrik, Hauptzollamt, Hamburg, case 249/85, reinforced that even administrative-style decisions can create rights for individuals. For the exam, be ready to identify decisions in scenario questions and explain how they differ in scope from regulations and directives. So to summarize this segment, regulations are fully binding and directly applicable. They don't need national implementation. Directives are binding as to their result, but must be implemented into national law. They can sometimes have direct effect. Decisions are binding only on those to whom they are addressed, and they too can have direct effect if their terms are sufficiently clear. These distinctions are core to understanding EU secondary law and will almost certainly show up on your exam. Be sure to cite Article 288 TFEU and back up your answers with case law. Now that we've covered the binding instruments, let's take a look at the softer side of EU legislation. Welcome back to FE1 Made Simple. In this segment, we're stepping away from the binding forms of EU law, like regulations and directives, and into the realm of soft law. These are non-binding legal instruments, specifically recommendations and opinions, both listed under Article 288 TFEU. While they lack enforceability, understanding them is crucial, particularly when discussing the nature of EU legislative power, judicial review, and institutional accountability. Soft law refers to rules or guidelines that do not have binding legal force, yet they influence the behavior of member states, institutions, and even individuals or businesses. Recommendations and opinions are the two primary forms. Under Article 288 TFEU, recommendations and opinions shall have no binding force. But that doesn't mean they're irrelevant. In practice, they can shape policy development, influence the interpretation of binding legislation, serve as precursors to future legislation, and reflect institutional consensus. Let's unpack each one. Recommendations are typically issued by the Commission or Council to advise member states on how to proceed in certain policy areas, While not binding, they often signal the direction of future EU legislative activity or suggest harmonization efforts. A key case to remember here is Grimaldi v. Fonds des maladies professionnelles, Case 3-22/88. The CJEU held that although recommendations are not binding, national courts must still take them into account when interpreting measures meant to implement EU law. This gave recommendations a kind of interpretative weight. Exam tip: don't dismiss recommendations too quickly. They can be pivotal in understanding the objectives behind binding legislation, especially in policy-heavy areas like health, environment, or economics. Now moving on to opinions. Opinions are evaluations or assessments issued by institutions such as the European Commission, the European Central Bank, or the European Economic and Social Committee. They typically come before formal legislative proposals. Although opinions don't impose legal obligations, they are important because they help explain the rationale behind proposed legislation, assess the compatibility of national laws with EU principles, and provide early-stage guidance to shape legislative development. For example, an opinion from the European Central Bank might assess the financial implications of a proposed regulation. Though it's not binding, it can significantly shape the final outcome. Exam tip: opinions can come up in exam scenarios focused on legislative development or institutional roles. Be ready to explain their advisory nature and how they influence lawmaking. So, why do recommendations and opinions matter in exams? They are commonly used in soft harmonization strategies, especially when member states resist full legislative integration, the open method of coordination in areas like education and social policy, and as groundwork for future binding acts in politically sensitive or evolving fields. And importantly, since they don't create legal obligations, they also can't be challenged in court. In Inuit Tapairit Kanatami v. Parliament and Council, Case T18/10, the General Court confirmed that only acts with legal effects can be annulled under Article 263T FEU. This case clarified that recommendations and opinions fall outside the scope of judicial review. To recap, recommendations are non-binding suggestions that may still influence courts and policy. Grimaldi. Opinions are institutional assessments that inform or support legislative efforts. Neither has binding force, but both shape the EU legal landscape through soft influence and coordination. Coming up next is delegated and implementing acts, and how the EU manages the ongoing adaptation and enforcement of legislation. Welcome back to FE1 Made Simple. In this segment, we'll decode the legal mechanisms that allow the European Commission to manage the fine-tuning and day-to-day enforcement of EU legislation, delegated and implementing acts. These may seem procedural or dry, but they regularly feature in exams, often in problem-style questions on competence, institutional roles, or legislative hierarchy. So let's break them down clearly and connect them to the underlying treaties and case law. Let's begin with the legal foundation. Both delegated and implementing acts are rooted in the Treaty on the Functioning of the European Union. Article 290 TFEU governs delegated acts. Article 291 TFEU governs implementing acts. Both empower the European Commission to act, but under different conditions and types of control. Delegated acts allow the Commission to supplement or amend non-essential elements of a legislative act. These are typically used when technical details need to be added or adjusted after the main legislation is passed, especially in complex areas like finance, food safety, or environmental regulation. Some of the key features include The delegation must be clearly outlined in the original legislative act. The Commission may not go beyond non-essential elements. The European Parliament and the Council can revoke the delegation or object to individual acts, but they cannot amend them. For example, a directive might lay down broad investor protection rules, and the Commission may later adopt a delegated act specifying technical disclosure requirements. This raises an important exam point. Delegated acts are a frequent topic in legislative process questions, especially where the distinction between essential and non-essential content is in dispute. Now contrast this with implementing acts. These are used to ensure that EU legislation is applied uniformly across member states, especially when national implementation could create divergence. Areas like customs, agriculture, or product labeling often require implementing acts. Some key features include they are based on existing legislation. They focus on execution rather than amendment. They are adopted using comitology procedures. A leading case here is Commission v. Council, C377/98, which stressed that bodies must have clear treaty-based authority to adopt either delegated or implementing acts. So what's the difference between the two? Let's recap in simple terms. Delegated acts, Article 290. Amend or supplement non-essential parts of legislation. Implementing acts, Article 291. Ensure legislation is applied uniformly. Delegated acts are monitored by Parliament and Council. Implementing acts are overseen by committees of member states via comitology. Pro tip: in the exam, if asked whether a measure is delegated or implementing, ask yourself, is it introducing new rules or amending legislation? That suggests a delegated act. Is it specifying how to apply existing rules consistently? That points to an implementing act. Now let's talk briefly about comitology. Comitology is the oversight mechanism by which member states monitor the Commission's use of implementing powers. There are two primary procedures. The examination procedure, used for sensitive areas like taxation and environmental rules. It requires a qualified majority of member state representatives to approve a measure. The advisory procedure, used for less critical matters. Here, the committee gives a non-binding opinion, and the Commission retains discretion. For example, if the Commission wants to establish new inspection standards for agricultural produce, it might use the examination procedure. If the committee opposes the proposal, it cannot proceed as planned. Comitology is another exam favorite, often tied to questions about institutional balance and democratic legitimacy. To wrap up this segment, remember, know who adopts which act and under what treaty basis. Be prepared to analyze whether an act has gone beyond the powers delegated, ultra vires. Understand when comitology is required and how it functions. And always connect your answers to real cases and articles, like Articles 290 and 291T, F, EU, and Commission v. Council. We've covered the nuts and bolts of how EU legislation operates, but holding it all together are three essential principles that often come up in problem questions: legal basis, hierarchy, and institutional competence. These are the building blocks of EU law's structural framework, and they help determine whether an EU act is valid or has gone beyond its limits. Let's take them one at a time. Let's start with the legal basis. Every EU act must be grounded in a specific provision of the treaty that authorizes the institution to act. This reflects the principle of conferral. The EU can only act where member states have granted it the power to do so in the treaties. If an act has one clear objective, it must be based on a single legal basis. For example, in the harmonization of indirect taxes case, the court ruled that if a measure is primarily environmental in nature, it should be based on Article 192 TFEU, not on internal market grounds under Article 114. In contrast, if an act pursues two equally important objectives, say, internal market and consumer protection, it can be based on multiple legal bases, but only if those articles follow the same legislative procedure. In Commission Vive Counsel, the court examined the purpose of the directive and made it clear that the legal basis must reflect the Act's main objective, not just its effect. In any problem question, always ask, what is the Act's dominant objective? That question usually points you to the correct treaty article. Next, let's talk about the hierarchy of EU norms. EU law is structured in levels. Primary law includes the treaties, TEU and TFEU, the Charter of Fundamental Rights, and protocols. Secondary legislation includes regulations, directives, decisions, delegated and implementing acts. International agreements like WTO or ECHR treaties. General principles such as legal certainty, proportionality, and equality. And finally, case law from the CJEU, which provides authoritative interpretation. This hierarchy matters, especially when laws conflict. For example, a regulation under Article 288T FEU overrides any conflicting national law. A delegated act that lacks a proper legal basis can be annulled under Article 263T FEU. A directive that has not been properly transposed, but whose deadline has passed, can still be relied upon by individuals if it meets the test for direct effect. You should also remember the two foundational doctrines of EU law. Supremacy. EU law takes precedence over national law. Costa Simmenthal. Direct effect. Certain EU laws can be relied upon directly in national courts. Van Gend and Loos. Now let's look at institutional competence. Even when an EU institution wants to act in good faith, its actions must stay within the powers granted to it by the treaties. If an institution goes beyond what's allowed or uses the wrong procedure, its act can be annulled. In Roquette Frere, for instance, the Council adopted a regulation without first waiting for the Parliament's opinion. The court struck it down for violating the legislative procedure. In Commission v. Council, the court confirmed that the Commission needs clear legal authorization from the treaties before it can adopt delegated or implementing acts. Institutional checks and balances help prevent overreach. For example, delegated acts can be vetoed or revoked by the European Parliament or the Council. Implementing acts must go through comitology, where member state representatives oversee the Commission's actions. Finally, the general principles of EU law, such as proportionality, legal certainty, and protection of fundamental rights, act as safeguards. Even if an act is procedurally correct, it can still be challenged if it undermines fairness or violates charter rights. If an act looks lawful on paper but feels unfair, think about whether it breaches general principles or charter protections. How to tackle a problem question. Here's a checklist. Identify the legal basis. Which treaty article authorizes this act? Check the hierarchy and competence. Is the right type of act used? Regulation? Directive? Decision? Was the correct procedure followed? Legislative? Delegated? Implementing? Consider supremacy and direct effect. Can individuals rely on this act in national courts? Does it override national law? Look out for institutional overreach. Has the Commission or Council exceeded its powers? Does the Act breach any general principles or charter rights? Suggest a remedy. If it's ultra vires or lacks a valid legal basis, recommend annulment under Article 263T FEU. And that wraps up our final segment on the sources of EU law, complete with treaties, instruments, procedures, hierarchy, and institutional limits. Keep this framework in your back pocket. It's often the key to solving complex FE1 problem questions. Thanks for listening to FE1 Made Simple. I'm Jessica. See you next time.